Hello, my name is Alistair Hodge, and can I welcome you to this short half-hour session on drafting skeleton arguments. Over the course of the next 30 minutes or so, I'm going to be giving you some pointers which will hopefully improve your skills in the drafting of skeleton arguments. Of course, the term skeleton argument contains two component parts. Firstly, the argument, and secondly, that argument should be skeletal. In other words, the bare bones of the argument that you are going to make to the court. Let's deal firstly, if we may, with the fundamentals of argument. For many years, I've always used a definition of an argument that we make to a court as being a series of structured propositions supported by reasons to persuade the tribunal to conclusions of fact or law towards the desired result, the winning of the case. But if we break down that definition of an argument into its five component parts, it does warrant a bit of individual consideration. Firstly, a series of structured propositions. In theory, in terms of the argument, you should have those propositions by what I call the formulaic nature of law. In most areas of law, especially in the civil jurisdiction, in order to establish liability, there are a series of stages through which a party has to go, or a number of hoops through which a party has to go in order to establish a state of affairs. Take, for example, in my field of practice, a claim of constructive dismissal. What does a claimant have to establish in order for there to be a constructive dismissal? Firstly, that the claimant resigned from their employment. Secondly, that there was a fundamental breach of contract on the part of the employer. Thirdly, that the employee resigned at least in part in respect of that fundamental breach. And fourthly, that the employee did not wait too long before resigning so as to have waived the breach of contract and or affirmed the contract of employment. So that establishes a dismissal within the meaning of section 95(1)(c). And those characteristics, if you like, if you're acting for the claimant, if I am in this particular case, leads me to my series of structured propositions. The claimant resigned. There was a fundamental breach of contract on the part of the employer. The employee resigned in response to the said fundamental breach. The employee did not wait too long before resigning so as to have affirmed the contract or waived the breach.